If you turn it on, you'll have control of the recording.
Awesome. I've got it.
Okay.
Thank you. And we kind of have like a introduction protocol too, so we can introduce ourselves as well. Just waiting on one more student.
You're my last appointment of the day, so there's no rush.
Thank you. Have you had a busy day today?
It was good. Thursdays are my office hour day, so it was mostly just dealing with student questions about the exam.
Oh, gotcha.
Yeah, so I turned back their midterm last weekend, and I had the final exam in a couple of weeks. So.
Oh, wow. Oh, there she is. Awesome. I think we have.
Hi.
Cool. We're all here. Well, like I was saying earlier, it's an honor to share space with you here today. And thank you so much for taking the time to meet and talk with us. We're excited not only just for like our group project, but also simply it's an honor to be able to listen and learn from you and your stories, especially given your field and the intersectional work that you do. We think you'll have such a unique like positionality and perspective on some of the larger themes that we're seeking to explore. So I just wanted to start off by saying thank you so much. We really appreciate it. A little about our project to kind of situate us into this space. The practice of talking stories refers to the way that we're in relation with one another, where we make space and time for oral practices and the sharing of experiences. So using this framework, we're seeking out ways that scholars who place emphasis on centering marginal voices are approaching their work and praxis, along with learning the stories of themselves, so how they're situating their own identities into these concepts, and combined through this practice of being like reflexive, we're kind of looking at how these narratives showcase relationships with time, place, space, and land. And so kind of utilizing this medium of talking stories as an organic response that can add to the collective conversation of how do we bring people together and how do we recuperate past that's like they've been deliberately fractured. So that's kind of like our abstract of our project. And like we had mentioned, this is super informal, no right or wrong. We just want to have a space for words and experiences and identities to exist and overlap and just be. So we have an interview protocol of our own that involves centering ourselves into this sacred space of talking stories. And we'd like to start with just explaining who we are. So our name, what we're studying, our program, where we're from, and who we bring with us to this space here. And we can start with us. I can go first, and then that can kind of lead into our first general question, which is, who are you and where do you call home? And then we can kind of see where the conversation goes from there, if that's okay with you.
Sounds great.
Awesome. O Kiana Lynn Makayan Anderson Koinoa, no hilo waikea ahupua amayao. Hello, my name is Kiana Lynn Makayan Anderson. I am from the Big Island of Hawaii. I am in the PhD English Literature program here, and my research interests include looking at identities that are being formed on the islands of Hawaii, Asian Pacific Islander studies, indigenous, post-colonial, and kind of decolonial theory, all in work and inform my work. I'd like to bring the stories of my ancestors here to our conversation and allow our experiences and conversations to intertwine and overlap in this sacred space. So honored to be here. Shione or Rachel, if you want to go.
I'll go. My name is Rachel James, and part of that is a self-given name, which goes into who I'm bringing into this space with me, would be all of the women in my family whose names I don't know any longer or never knew. I am a master's student in the English Literature program, and my interests include revolutionary texts, American literature, concepts of freedom and mythology. I come from all over America, but really my family calls the Midwest home. So Missouri and Wisconsin is where my maternal side is from. And I'm just so excited and honored to be sharing this space with you all and getting a chance to talk some more and just expand how I think about things and hear things.
Hi, good afternoon. My name is Shione Lynn Peely-Lister, and I am a PhD student in sociology. Let's see, where do I call, where am I from? So I grew up in Washington, just outside of Seattle. My mom is from California, and my dad is from Utule, and my stepdad is from Algiers, just outside of Algiers, and Benin in Algeria. So lots of different homes that I kind of am always, pulling energy and power from. Who do I bring to this space? I defend my master's tomorrow, and so I've been thinking a lot about my grandmother. She passed in my first year of the program, but she has been and continues to be such like a huge inspiration for me, and kind of just like courage to keep going. So I'm bringing her with me today. And yeah, it's such a pleasure to share space with you all, and I'll turn it over. Thank you.
Yeah, so I guess we can start with our first kind of major question, which is just who are you and where do you call home? And that's very general. You can take it wherever you would like to take it.
Okay, let me start by saying when we ever have face-to-face conversations, or at least Zoom face-to-face, part of the interchange is always body language, not just words. But so in interpreting my body language, you need to know I have Parkinson's. So a lot of times what appears to be random movements are random movements. Sometimes it appears like impatience or, not like I'm not listening, but I am. And it's not impatience is what you're saying. It's just the disease. But I am Melissa Tatum. I'm a law professor. But more than that, I'm a professor who works with graduate students, and mostly doctoral students, because I love to learn from them. I learn as much from my students, I think, as they learn from me. I've worked with graduate students my whole career because both students are graduate students. But about 15 years ago, I started working with master's and doctoral students in law, and that expanded into interdisciplinary work. And a lot of that is influenced by my family. I grew up in a suburb of Dallas, and I spent my about a decade living in the state of Michigan. And then I took a job at the University of Tulsa. So most of my career was, the first part of my life and my career were in Tornado Alley in the Midwest, very Midwestern style upbringing and living. And then in 2009, I moved out here to take a job at the University of Arizona. And when I did that, I moved my family, my husband and I moved halfway across the continent from both our families, because his family was in the Tulsa area and my family was in the Dallas area. And that was hard for us to move, but the opportunities here to work with graduate students and to work interdisciplinary with so many departments across campus was just something I couldn't pass up. My husband was very supportive of that, and he also had lived in Tucson for about a year, several years before we got together. And then he really would he wanted to return to this area. So it worked out perfectly for both of us. But within a week of being here, even though I grew up in the Midwest, the desert was very foreign to me. It just was home. Something about it just seemed like this is home. And so we've settled in here for the rest of we plan to stay here in Tucson. And being here has allowed me to get to know people in a different part of the country with a different way of living, a different culture. And it's just enriched my work. I think that would probably be my answer to the first question.
Yeah, that's so awesome to kind of see like the merging of cultures here. And I appreciate how you said it was foreign to you, but it felt like home, and that feeling is what we need to pay attention to, and it's so important. The feeling of place and belonging is something that we seek to know within everyone's story. So thank you so much for that. Kind of moving forward into like the theory and praxis, given like your interdisciplinary work, we're interested to know how you approach theory and praxis within your work, if you use it, how you implement it, how you see its like function within your work, and also like your work with the MA and doctoral students as well. The relationship between who you are and the theory or the theory that you use or don't use.
It's going to be a little bit long-winded answer. It's a winding storytelling answer, but it's when I started teaching in 1995, I was very much what we call a procedural specialist. I specialized in both civil and criminal procedure, and I taught the procedural law classes. And I was attracted to those because basically the Anglo-American legal system is premised on the idea that to achieve a fair result, we need to have a fair process that applies to everybody equally. If we have a fair process, we'll get a fair result. And if we don't have a fair result, we need to go back and fix the process. So it was very much a belief in the process and in the system process. The more I worked with those topics, the more I taught different classes, and the more I worked with Indigenous peoples, the more I realized that that was not true. That was sort of a myth that we've been told about the legal system. The process is very manipulated to reach certain substantive results and to avoid reaching certain substantive questions. And then I started looking for patterns, and I noticed the patterns where the courts were changing the process when it looked like the majority was going to lose power, right? When Indigenous communities were going to win the suits. And so that troubled me greatly. And I knew when I went to law, I knew when I started teaching, I wanted to concentrate in Indian law and Indigenous people's issues. I'd actually gone to the University of Michigan to study international law, but I quickly realized when I took a class, and I was writing a paper, I discovered Indian law. It was not even taught at Michigan when I was there. Stumbled across the topic and realized it's all about how tribal governments fit with state and the federal government. So all the issues in international law that interested me. How do nations relate to each other? How do they fit? What powers do they have in relationship to each other? We're a microcosm here in the United States. That's sort of what interested me in Indian law originally. And in Tulsa, we had at the University of Tulsa, a very strong Indian law program at the time. It's now diminished, but at the time it was one of the top 2 programs in the country. We had a wealth of faculty. There were 4 faculty members senior to me. That meant as a junior faculty member, I wasn't able to teach any of the basic Indian law classes. They were taken by senior faculty. So I was able to carve out a seminar, and I created a seminar called Protection of Minority and Indigenous Cultures. I began looking at cultural issues. And I quickly realized in dealing with my students that first I had to convince the students that they had culture. Culture was not just something that minority groups have. It was not sort of just the majority culture had a culture that was being replicated in the legal system, and they were viewing things through the cultural lens. So I started figuring out ways to have students realize that everything that they process and all their arguments and their reactions were being filtered through their cultural lens and their filter of their experiences and their upbringing. And so I started trying to figure out ways to make that transparent and make people realize what their cultural filter was and how that was affecting their judgment. And it's hard to put yourself into the other person's shoes, right? But for negotiation strategies in law, we teach people how to anticipate what the other sides are going to argue, what points are going to be made. So I started saying, you have to realize perspectives that the other people bring to the table in order to understand and predict what's going to happen, so that you understand what they're talking about. And in the process of doing that, we started realizing that sometimes there were words we used and phrases we used to mean one thing in one culture that meant something different in another culture. So some misunderstandings were caused by just using the same word to mean different things. And in fact, an illustration of this is when I came to Arizona. Shortly afterwards, I started working with a professor from the University of Leeds, and we had several projects we wanted to work on together. So she took a research leave and spent 6 months here. And when she first got here, we were outlining the book and our book proposal that we wanted to put into the publisher. We spent an hour and a half getting so frustrated with each other before we realized that we were using the word introduction to mean 2 different things. Introduction for a British academic book meant essentially the first chapter, the first substantive chapter. An introduction in a US academic book meant essentially just an overview, like an extended preface kind of thing. And so once we realized that, then we broke through the walls. But that hour and a half was very frustrating. We almost called it our partnership quits. And we're from the same legal tradition, speak the same language, and from basically similar cultures. And that caused such a rift and misunderstanding. And so that's why I try and point out with my work. And so then when I came to the University of Arizona, I combined that with the procedure issues and the disillusionment of the procedures and said, if courts aren't going to serve justice for Indigenous peoples, if we can't use the court systems, I can't trust the court systems to be fair, how can we trust the legal system? Does that mean the legal system is defunct? So what we started doing was I started working with a group called Spaces of Indigenous Justice. And it was a workshop and a series of workshops and a series of articles that we put together. It's basically a coalition of faculty from around the world that work with Indigenous peoples and Indigenous issues. And we started trying to compile stories and anecdotes of where Indigenous people used something other than the formal legal system to solve problems. And they reached an answer that everybody was happy with. And most of these cases were sort of viewed as being just the right person at the right table at the right time to negotiate the solution. We started saying, is there something we can figure out some common themes? Can we reverse engineer these so that it's not just mere happenstance, but we can make it happen? We can get the right people at the right table at the right time. And in doing that, we found two interesting things. The first thing was that academic theory was useful in explaining and predicting what could happen. And we hadn't expected to see that connection between academic theory and the practical solutions. And the second thing we discovered is that interdisciplinary and multi-methodological approaches were critical. The language of rights was not the appropriate way to do it. But by getting everybody at a table as equal experts at the table, not with the lawyer controlling things. Like, there's a water law problem, there's a water issue. If the lawyer controls things and tells the hydrology person, I need you to testify this as my expert witness. And Indigenous person, I need you to tell this as the history. That doesn't work. The lawyer's running the table, directing what people should say from the lawyer's perspective. If everybody's given the chance to articulate their perspective on the problem and their approach to it, and everyone listens to that and hears that, there's a significantly higher likelihood of a good solution being reached, and a fair solution being reached that all parties are happy with. So by getting people at the same table, listening to each other, understanding where each other's coming from, understanding the interest that each group has in whatever the problem is, that allowed for very effective solutions. And so that really changed the way I approach things. And that's why I can still have faith in the system. I still have faith in the legal system, even if I don't have faith in the courts. So that's sort of how this all comes together for me in theory and practice.
But yeah, that is such a great answer. I really appreciate how like you took us through like that learning process of like discovering like how the interdisciplinariness is so critical and necessary, especially when working with like the legal system and the recuperation of like Indigenous peoples and stories. That's so awesome, and something that we're seeking to emphasize in our project as well. It's like, what is the methodology that these scholars are using to actually implement and do that work? And this kind of leads, I guess, into like the third question, which is you kind of touched on, you learned the anecdotes you said about like of the Indigenous peoples. So our question is, how do you view the role of storytelling within your work? And that can be taken however you see, but we're very much interested in these stories and experiences of these people being situated directly in the center of these work.
There's a general feeling among lawyers and law faculty, right, that law is not about stories. Law is about facts and interpreting facts. There's an article by one of my colleagues named Carol Rose about how the whole history of our legal system is actually built on a story, right? The state of nature, right? Our legal philosophy, our political philosophy in the United States is built on this Western liberal tradition. Sorry, I'm under the flight path for Davis Monthan Air Force Base. You're hearing some jets going overhead. So the whole political philosophy is based on this idea that the individual is the basic rights holder, and government exists to protect the individual rights of the people, and people give up some of their rights to autonomy and privacy in order to be protected by the government. And this idea is built on this idea of the state of nature, which is a story. It's a myth, right? It's a story that's created to explain this political philosophy. And so even though the American legal system doesn't tend to think this itself as storytelling. It actually is at the foundation of what we do. And storytelling is a good way to explain things in a way that is understandable by many people. But also stories are a way to extract law, not just, I mean, one thing is the anecdotes that the group I'm with has compiled and collected allowed us to reverse engineer and figure out what happened. But also there's a colleague of mine named John Burroughs, who's a law professor at the University of Victoria. He has a book written called Drawing Out Law. He's from one of the Canadian First Nations. And he talks about how the law is told and can be extracted from stories and from the stories that are taught to in his culture. And so it's just another way of telling, explaining things to people. But we also have court decisions or law in our society, in our legal system, right? Court decisions count as precedent. They're just stories of what happened and of what the court did. Just another way of thinking about where we find law.
I love that answer. And it's so, when you put it that way, it just becomes so simple, you know, like an explanation for an articulation of the way we live and the way humanity functions, which is so central, I think, for us to show like the emphasis that stories permeate every aspect and field like of our lives, which is so interesting. And this leads into our next question, which is, how do you approach the ideas of space and time within your work? A lot of what we've been interested in for this project is we've been grappling with like methodology, and sometimes seeing things linearly has its faults in syllabi, even in just viewing history. And so we're interested to see from your point of view how you view time and in that way.
Time and space are intersecting concepts that are very strange in the law, right? The law tends to tell things very linear way, but a lot of what law happens, it seems to be, I think a lot of the linear aspect of law is an attempt to impose order and to explain things in a structured way, in a systematic way, but it doesn't always fit comfortably with many concepts, right? With certain concepts. Like, for example, the legal system has a very linear concept of in intellectual property. Just if we're talking about patent or trademark or copyright, if it's, you have to be able to identify the originator of the idea. If it's lost in the midst of time, then that doesn't count, right? It's too old. It's not a new invention, right? So you can only protect it if it's new and you can prove who came up with the idea and trace it back. But yet, that way of looking at things is very different than the way many cultures work at it. So this is one of those cultural filter ideas and concepts that people have to realize that this is driven by a certain cultural approach. There's two other examples. One is with protection of sites and sacred sites. There's a statute called the National Historic Register Act. I got that a little wrong. It's the National Historic Places statute, the one that gets them listed on the National Register. In 1992, it was amended to create the option to protect traditional cultural properties. And these traditional cultural properties aren't just tribal and indigenous. It's any special place like Greek town, Chinatown, you know, where there's a discrete culture that's occupied a certain geographic space. But it has to, there's a time element added to it. It has to be over a certain period of time that this geographic space has become identified with this community. And once you, then it can be protected on the National Register of Historic Places. But as part of that, when you identify and you list a place, you have to identify the date at which everything's solidified and the date you're protecting it as. And this has become a critical element and a very effective tool for tribes in the United States when they're trying to protect their sacred places. Many tribal sacred places are on federal public lands because the federal government said we own all, by virtue of the fact that we're government, we acquired all this land from the Indians, so we didn't have to pay for it because they didn't have proper title to it under the English legal system. So they took all these vast swaths of the American countryside and land, and they put it under the jurisdiction of various federal agencies. And federal public lands are managed for a variety of purposes. but there's a site called Cave Rock, which is outside Lake Tahoe. And there was a very strategic approach to using these time and place statutes to protect the sacred sites. So what they did was the statute, the National Historic Preservation Act, that's the name of it, the NHPA, when it created the traditional cultural properties option, it put an affirmative burden on every federal land manager to identify whether any of the lands under their control qualified for listing, and if so, they were affirmatively required to start the listing process to protect the site. So a coalition of environmental protection people and tribal people approached the U.S. Forest Service, which was managing spot where Cave Rock was, and said, you're affirmatively required to protect the site. This is why it qualifies for listing, and here's the information you need to file your application for listing. And while we're doing this, I think it's time for you also to make a new management plan for the site in light of the fact that it's going to be listed. We need to manage what's happening here. And so if we look at this, we're listing it, it qualifies for listing on the National Historic Register because it's both critical to the Washoe tribe, and it's also a cultural transportation corridor for the larger U.S. population. It was a key corridor when people were traveling westward to settle the country. And so if we look at the key date of the statute, the really critical date is in 1960s, I think it was 65, 63, I forget the exact date, when the last Washoe medicine person visited the site. And so that's the site we need to freeze frame. We need to manage the site as of that date. And they said, okay, that sounds good to us. I always said, now, if you manage it as of that date, there was no climbing allowed in the park, the National Forest at that time. So you have to forbid all climbing on the rock, on Cave Rock. And I said, okay, so they signed the order forbidding all climbing. A climbing group sued and said this was an unconstitutional establishment of religion, and it also unconstitutionally barred their use of the site. And the tribal group and the environmental group said, if you look at this actually, you did what your duty required you to do. You followed your legal obligations. And also, the climbers are the ones that are taking the resources of your rangers. They're the ones that the Forest Service rangers are having to come deal with the climbers who don't have permits, who are littering the site, who are poured on the legal masonry floor without permission. And they're the ones tying up your rangers and keeping them from doing their regular duties. And so the Forest Service manager wrote his report, said that, and the federal government gets deference. Federal agencies get deference when they interpret the statute that they're charged with, that created their agency. And the federal court almost said word for word with it. But the U.S. Forest Ranger in charge of the site had said, this was not an establishment of religion. This was a fulfillment of his statutory obligations. And he was just doing what Congress had ordered him to do. And that there was yes, it did forbid climbing in the site, but that was because the date that he was supposed to manage it as, there was no climbing at the time. And so federal law required him to forbid climbing. And so all the claims were dismissed very easily, and the tribes got their way. But yet until a few years before they started consulting tribes in the early stages in the management of sacred sites, tribes were routinely losing every case they brought and every effort they made to get access to their sacred sites. But by switching the space and the time of the dispute from being litigated after the agency had come up with a plan to the agency inviting them to participate at the very early stages of the development of the plan, they were able to get their perspective heard in a way that made a difference. So by changing the timeline of their intervention and their involvement, that got them a voice that they didn't have before. And so that's what I look at place and time and space as opportunities to look for creative solutions and as ways to perhaps look at a new interpretation of things.
Yeah, that is so fascinating. I like how you talk about, like, in law specifically, there's what counts and what doesn't count, and that's restricted by almost like this linear concept of time and the ability to recall certain things, and that if it cannot be made legible, it doesn't count almost. And so I appreciate that perspective of like shifting our understandings of time as like this opportunity to look for like these creative solutions that you're talking about. I think that is so special and something that has to be recognized when dealing with culture specifically, that not everyone sees culture and time in this linear Western way, which becomes difficult to navigate, especially in like the legal realm, as you just mentioned. So I really, really appreciate that answer. And that your answer actually segues perfectly into kind of our last question, which is how do you see your personal relationship to the land, and then your relationship to the land in the work that you do? You kind of touched a little bit on that, and kind of shifting the way we view time in relation to place and culture. So we're curious to know your relationship to land and how you function within it.
I don't feel that I have a relationship with the land the way some cultures, some people do, but I understand that is my position, right? That's my culture filter doing that and saying that. I do think my relationship with the land is sort of more of an environmental protection status, just sort of general interest in making sure the environment's here for the next generation. But I do recognize that land has different relationships to different cultures. And it's part of being conscious about my own cultural filter, realizing that just because I don't have that relationship with land doesn't mean that that relationship doesn't exist and isn't valid. It's just that it's not a part of my culture and my training and my experience. So I try in my work to be sensitive to that and to understand and to be a listener so that I can hear and understand those perspectives and those relationships. Because if they don't come naturally to me, I don't necessarily intuit that. My training doesn't work that way. But by trying to be conscious that other people have a different relationship with land and listening and hearing what they say about that relationship helps me develop a better understanding of how those relationships work.
Sorry, I was coughing. Thank you so much for these wonderful answers. Rachel, Shione, I don't know if you have anything else to add. In our kind of like closing protocol, we just like to offer our own takeaways and appreciation of what we are taking away from this space. And like I've been saying, I'm so grateful for all of these answers, especially this perspective coming from sociology and literature. We don't encounter this as often as we might want to. And so we really appreciate these perspectives, and it gives us almost like a tangible methodology to think about how we're navigating not only like policy and law, but in academia as well. It's really helpful and generative. So thank you so much.
I will jump in next. I just also want to reiterate my thanks. I especially have a deep interest in the way storytelling and law intersect and like the relationship between the two of them. And like in the past, a lot of that has been in how either legal documents or court cases are influenced in the ways that like story is told and understood, especially as you have people taking the stand and like, you know, trying to evoke a certain like archetype or whatever, or following patterns in story to tell a legal case. And what I really appreciate about this and what you said is, in the same way that time and space are really ephemeral and hard to track in like very tangible ways, sometimes I feel that story operates the same way, like not the book or the container of the story, but the story itself is very difficult to define and like pin down and say, we're dealing with this. And so what's really interesting to me is when you were talking about the Preservation Act and the ability to think of time and space in creative ways and use that as a way to restore or to protect sacred lands of Indigenous people here in America, it also has me thinking of ways that perhaps story could be tracked in similar ways in recuperation, restoration methods, not in just like law, but in like identity, in like this academic space that we're in too. and like as a method of thinking about who is in conversation with us and who is not in conversation with us, and what stories can and cannot be told or known. And so I just, of everything today, I'm really appreciative of that, and going to be definitely taking that in like the ways that I think about and actually interact with not just literature, but theory too, in my work. So thank you so much for that.
Similar to John and Rachel, can you hear me okay? Yeah, okay. My Wi-Fi is kind of laggy. Similar to Kiana and Rachel, just want to reiterate my thanks and gratitude. For my first 2 years, I studied the sociology of law, and that is a possible focus. I'm very unsure what I'm doing here. But after, like, I've learned a lot about the law from the sociology side, and taken a class in the law school, but this was like a really, like an honor, a treat to like get to talk to someone from this, talk to you from law, and like also gain this like critical kind of like outlook that I haven't seen or haven't been able to learn from. And so thank you for that. I think one piece I'm really taking away out of many, but one of them is more of the like pedagogical part of your first story about not being able to teach the certain classes. And so you decided to make your own, and what that, the way you framed like helping people come to their own terms with what their culture is. I found that really powerful, and like such a great example, I think, of what I hope to do. And I do love to teach. And so that was just a really nice kind of like a reminder of the ways that we can still do what we want to do, even if we're working within restraints from like our department or whatnot. So thank you for that.
Thank you for the opportunity to talk with you guys. I really enjoyed the conversation.
Yeah, thank you so much. And we plan to send you our final project as well when that's completed and compiled, and it should be done like in like early December. So we hope to keep in touch until then. And I just again, thank you so much. I appreciate you taking time out of your day. It's such a blessing. And I hope you have a great rest of your night.
Thank you. You guys have a good rest of the week, and I look forward to seeing your final project.
Thank you.
Bye.